Good day, ladies and gentlemen. Welcome to today's live broadcast of the Igbere People Forum. With us today is Barrister Emmanuel N Ukaegbu. He will be joining us to discuss the topic, legal procedures which non-lawyers may need to know. But let's start by introducing ourselves. I will introduce myself and then he will introduce himself and then we'll take it from there. Okay, first of all, the host is the admin of the Igbere People Forum, Mr. Ukaegbu, who hails from Angmakwo, Igbere. So let's give Barrister Emmanuel opportunity to introduce themselves. Emmanuel, please tell us where, please introduce yourself.
Okay, my name is Emmanuel. My name is Emmanuel N Ukaegbu. I am from Angmakwo, Igbere. I'm a legal practitioner and work with Akoma and Akomas. We have offices both in Abuja and in Aba, but I'm currently practicing fully in the Abuja office.
Okay, thank you. So without wasting much of our time, so we will start with the topic, bail procedures. So let me start. If somebody is arrested for any reason whatsoever, what are the standard procedures legally that can be done in order to bail that person?
Okay. Well, whenever anyone is arrested, that person, as of right, is entitled to bail. By the provisions of our Constitution, it is a fundamental right of every citizen of this nation that whenever anyone is arrested, that person is entitled to bail. And for you to, get bail, it depends on the stage of the thing that led to your being detained or arrested. Assuming one, because that brings us to types of bail, because we have bail by the police and bail by the court. Bail by the police is when an accused person is still under the detention of the police. The police officer or his superior, the investigating police officer, which we call in the local parlance IPO, can exercise his discretion to grant that suspect a bail. And the essence of bail is just to ensure the attendance of the accused person, either to enable them charge the person to court or to continue investigation whenever his presence is needed. So presently, bail is such that for you to deny one that right of bail, you have to show why that person should not be entitled to bail. Before now, the onus is on the accused person to show why he should be given bail. But by the provisions of Administration of Criminal Justice Act that is being operated in the nation right now, especially in our federal states and in our federal courts, the issue of denial of bail is now the accuser to show why that person should not be given bail. But ordinarily, bail is so that it inures to the accused person as of right. And presently, or before now, we have that notion that maybe those that can take surety of an accused person must be men. But any person, be it man or a woman, is eligible to take any accused person on bail. It is not an issue of is not a man or not a civil servant. What is the paramount thing is, can that person produce the accused person whenever he is needed? So both in the police, the police can give bail to anybody, be it man or a woman. And we have also bail pending trial. That is where the court will come in. Maybe whenever an accused person is charged to court, that person will, the lawyers that is representing that accused person will apply for his bail. And upon such an application, the court will exercise its discretion whether to grant or refuse bail. And upon granting that bail, the court will also give the condition upon which that bail is granted. What can be used, who can stand for surety, and other bail bond conditions. Upon fulfillment of those conditions, the accused person will be released to the surety, and the surety will ensure the accused person's attendance to court whenever he is needed. We also have bail as maybe what we call post-judgment bail. That is bail pending appeal, assuming after a full trial, an accused person is convicted. When he now becomes a convict, one can still apply for his bail. But the only thing in this last aspect of bail is that the onus is now on the accused to show why he should be given bail. And the conditions upon which that accused person can be given bail are more stringent and more compelling for any court to grant such a bail. It is such that you have to show why you should not be allowed to be in detention while your appeal is going on. So bail pending investigation is such, is the type that the police will always give, because right here in Nigeria, most of the times our police, they do arrest even before investigation. And it's unfortunate that that's their own procedure or the way they normally go about their business. Rather than go about, doing a discreet investigation, you see them effecting arrest before even carrying on their investigation. And that is why you see a situation whereby they are still investigating and they will not be able to charge the person to court, and they will keep on detaining the accused person. And any time that an accused person is detained beyond the provided time in our Constitution, that is a pure violation of that accused person's right. And maybe his lawyers actually bring a formal application to the court for the enforcement of the accused person's fundamental rights. So it is important that for our police to carry on their investigation properly before bringing the accused person to detention or to custody and then charging the person to court. And the Constitution had already provided the limit within which you can detain a person. That is within 24 hours, not beyond 24 hours where you have a court around you, and not beyond 48 hours where you don't have a court around. So any detention that is beyond this stipulated time is completely an abuse of the accused person's right to liberty.
Okay, so what shall the either the person do directly or by the person's lawyer in order to be given the bail?
Well, the person, anybody, you know, either his lawyer can actually walk into the police and request for the bail of the accused person. And the first of all, when you go to the police, the first step is to get to see the IPO, that is the investigating police officer, and thereafter, you will now request that the accused person be given bail. It is now within the discretion of the police to give you the bail condition for that accused person.
So, and if the police refuses to bail that person, so what's the next step?
When the police refuses to release the person on bail nor charge that person to court, the next step is to file a fundamental rights application against that against the police that is detaining the accused person. And it's a special kind of procedure. It is not a long process. It is a procedure that can be commenced in any high court in the nation. And it is such a procedure that can even be commenced before an arrest. When you are suspecting that you are about to be arrested or any of your fundamental rights is about to be breached, you don't necessarily need to wait for it to be breached for one to commence the enforcement of his fundamental rights. The only thing you need to show that your rights, any of your rights as provided in the Constitution from section 35, 36, 37, up to 45 of the Constitution is about to be breached. That's what gives you that local standing to apply. In any high court, be it federal high court, be it high court of a state, or high court of the federal capital territory, for the enforcement of your fundamental rights. And maybe in the prayers in such an application will be that to stop either the arresting authority or whoever that is about to violate your fundamental rights to restrain the person from that violation. If the person is already in custody and detained, you can actually ask for the person to be released unconditionally or charged to court, because that detention has gone beyond the 24 hours or 48 hours, as the case may be, as prescribed by our Constitution.
Okay, thank you very much. So which court shall the person start with? I mean, if you want to file something in court, so as a non-lawyer, lay person, if you will, you start from what court? I was told that there are 3 levels or 4 levels of court. I don't even know. So what level are you going to start with? Okay.
On issues of fundamental rights, you start from the high court. It is the high court of any state, the federal high court, or the federal capital territory that has jurisdiction to entertain any issues of fundamental rights. So you can go to any court of your choice, any high court of your choice, to apply for it. It has to start from the high court. It's not such an application that will go to a magistrate court or a district court or a Sharia court or a customary court. It must be from the high court.
Okay, thank you.
If you require, maybe the outcome of the judgment is not is such that you want it to be reviewed, you can now appeal against it after judgment.
Okay, thank you. So let's go to another topic. And this one is called landlord and tenant rights. So my understanding is that there are probably more tenants than landlords. So let's start with the rights of the tenants, and then we go to the rights of the landlord. But if you think we should start with the rights of the landlord, it's up to you. So what do you think? Start.
Okay. Well, on issue of landlord and tenants, we have different laws, recovery of premises laws in different states of the Federation. Maybe for the purpose of this presentation, I will just concentrate on the Recovery of Premises Act, which applies to the Federal Capital Territory and which most of the states, adopted as their own recovery of premises law. So it is more like a uniform rule, or what we can call a uniform rule. So by the provisions of that Recovery of Premises Act, it prescribes both the right of the landlord and the right of the tenants. And let me also put it this way. Issue of landlord and tenant is purely a contractual issue, in the sense that the landlord and the tenant can decide on what is their rights and privileges and liabilities and when they take such a decision, tenancy agreement, and whenever you have such an agreement and specifically agree on certain issues, or that you have agreed on those issues will now be binding and can be, will no longer, what is in the Recovery of Premises Act may no longer apply stricto sensu in governing the relationship between a landlord and a tenant. Now, a landlord is the owner of a property. Who owns the person that owns the property that the tenant took rent from. And that property can be house, it can actually be a bare land. And in all this, I will look at the right of the landlord. The right of the landlord is such that the landlord will give up either the whole of the premises or part of it. And when the landlord gives out the whole of the premises, it can actually be described as a demise premises. Or when it is part of it, you cannot call it a demise premises. So when a landlord gives out his house, he will collect rent from the tenant. It is that yielding of possession to the tenant and collection of rent from the tenant that creates the relationship. They can decide to have a written agreement or an oral agreement, but it is better to have it written than to leave it oral. And in any case where you don't have a written agreement, it will always, by our laws, the landlord will give the tenant exclusive possession of the premises or part of the premises that the tenant has taken. And the landlord will also have rights for inspection of those premises, while the tenant will have possession. And in any case where the landlord feels that he wants to take over or he wants to recover his premises, issuance of quit notices and other notices, what we call generally as statutory notices, will begin to apply. The landlord, for the landlord to recover his premises, he must issue a notice of a quit notice to the tenant. And whenever I'm talking about tenant, I'm talking about a tenant that is rent is still subsisting, not somebody that is holding over the premises. So if your rent is still subsisting, it then means that the rent you have paid is still running. So it is when that rent that is still running that, and the landlord wants to recover his property, the landlord will issue that tenant a quit notice. And that quit notice, the length of the quit notice is determined by the nature of the tenancy. The tenancy can be a yearly tenancy, or 6-month tenancy, or 3-month tenancy. It can even be a month tenancy, or even a weekly tenancy. So for a weekly tenancy, the tenant will be entitled to 1 week notice. For a month tenancy, the tenant will be entitled to 1 month notice. The same thing applies to a quarterly tenant that will be entitled to 3 months notice. For a 6-month tenant, he will also be entitled to 3 months notice, while a yearly tenant will be entitled to 6 months notice. But where the tenant is in arrears and he has not renewed his rent, where the tenant has not renewed his rent, that tenant will no longer be entitled to all these pieces, because in law, we need that tenant to be holding over the premises. So whenever a tenant is holding over a premises, he is no longer entitled to quit notice. This is a misconception of most of our tenants. They think as long as they are occupying the premises and they have not paid their rent, that anytime the landlord wants to recover the premises, that he must issue them with either 6 months notice or 3 months notice or 1 week notice, as the case may be. As long as you are in arrears and you have not renewed your rent, you are no longer entitled to any quit notice. The only entitlement that you have is what we call landlord owner's intention to recover premises, and it is a 1 week notice, 7 days notice of owner's intention to recover premises. Once that notice is served on the tenant, at the expiration of that notice, the landlord can now approach to a court with jurisdiction to apply to recover that premises.
So now in this case, what level of court is the landlord going to start with?
Okay, good. Now, the level of court is determined by the rental value or the prayers before the court. Assuming that the rental value of a premises is, say, 1 million naira, you cannot take an application or a suit to recover the premises to a court that its monetary jurisdiction is below 1 million. It has to be a court that its monetary jurisdiction is above 1 million. Or in the alternative, you can actually go to court, assuming there is an arrears of rent. You just ask for possession without asking for those areas of rent or means profit. When you ask for possession alone, you can go to either a magistrate court, a district court, or even a high court of your choice to apply for the recovery of the premises.
Okay, so now if a tenant feels that their rights are also being violated while still paying the rent, so what shall the tenant do, and which level of court can the tenant go?
Well, for the right of a tenant to be violated, that tenant will always have a right in tort. It can be by way of trespass. Just like I have earlier said, that once you rent a premises, the tenant will be given exclusive possession. And once a tenant is given exclusive possession, he has rights over that premises above every other person. So he can ward off trespassers, even including the landlord. That is why the landlord can only inspect his premises with the consent of the tenant. The landlord has a right to inspect, but he cannot barge into the premises in the name of inspecting premises. Inform the tenant and fix a time. And the tenant, on the other hand, cannot refuse him that right of inspection. The tenant cannot refuse him that right of inspection. So the only thing that the landlord needs to show that he has requested for the consent of the tenant to inspect that premises. And thereafter, on the appointed date, he can come in, look at the state of his premises, and then, go on from there.
Okay, thank you. So let's go to another topic which many people are interested to know about. And you mentioned contracts. So what is actually a contract? A lot of people have so much or so many different impressions and conceptions about contract. So what is a contract?
Well, a contract, is more of an agreement to do a particular thing. A contract is an agreement between two persons to do a particular thing or refrain from doing a particular thing, and also to take benefits or give out a thing between two or more persons. So for there to be a contract, it comes with a lot of elements, for there to be a valid contract. Elements like offer, acceptance, consideration, intention to create legal relationship, mutual obligations, and consideration. So, and in contract, what we call an offer is actually an equivocal manifestation of willingness to enter into a legal relationship, to open up a bargain between the offeror and the offeree. When you say offeror, what that means is that the person that is making that offer and the offeree is the person that is accepting that offer. So the offer has to be equivocal, and for the offeree to accept, and the offeree also has to give his own consent, accepting the offer that was given. And when such an offer is not okay to the offeree, he can make a counteroffer. So it goes forth and back until they are able to agree on all the issues. Until they're able to agree on all the issues, and it is at that point of agreement that you can actually, say that there is a meeting of mind. And furthermore, for there to be a valid contract, it must also be backed up by consideration. Consideration is that which is given in exchange for the offer that was made to you. And consideration must be a valuable consideration. It must not be sufficient. What it means that it must be a valuable consideration, it must be something of value to you or to the person that is making that consideration. It doesn't matter whether that consideration is enough or not. What matters is that you gave out something in return. So that is for the offer, the acceptance, and the consideration. And when it comes to contract also, you cannot, contract over illegality. Two persons cannot enter into a valid contract to do an illegal thing. So any contract in which the purpose to do an illegal thing is a void contract. That such a contract cannot be enforced by any court. So if an act is an illegal act, you cannot, enter a contract to do an illegal act because it cannot be enforced. We also look at the capacity of the people that are entering into a contract. For there to be a valid contract, the parties must have the required capacity. Adults that are of full age, persons of full age, adults, in some jurisdictions they consider 18 years, while in some they look at 21 years. So it varies from jurisdiction to jurisdiction. And based on that, they can contract. But a situation whereby one of the parties does not have that capacity, maybe either by infirmity of mind or body or age, such a person cannot validly, contract. But there are situations whereby maybe a person without capacity can actually ratify contracts, he has entered at age of capacity. And especially it applies to, contract of necessities like, shelter, food, clothing, and all that.
Okay, so now if somebody's contract is somebody breaks the contract, whatever the contract says. So what shall the person do?
Okay, now there are, remedies available to parties to a contract. One of which is enforcement of that contract. Assuming maybe any of the parties refuse to do his own part of the contract, you can ask for specific performance, what we call specific performance. What that means is that asking the court to enforce that contract make the party that is in violation to do his own part. You can actually ask for damages. Maybe what you have suffered as a result of the violation of that contract, you can ask for damages, and court can actually award damages. Example is that maybe a employer-employee relationship, contract of employment, it is difficult to ask for specific performance because you cannot, force a servant on a master. Why the employee can actually get damages against the employer. So the courts are there to enforce contracts, to award damages if it is such that can be enforced.
Okay, so which level of court can somebody who feels that a contract has been violated approach?
Now, the level of court, what determines the level of court is the subject matter. For instance, contract that relates to land, it is only a high court that has jurisdiction to entertain issues of land. And it is the high court of where the land situates that can adequately adjudicate over it. Maybe the subject matter also. There are subject matters that affects, it is the subject matter that will actually give a particular court jurisdiction. There are subject matters that it is only a federal high court that can entertain it. And the parties also involved. It is the parties determines the court you go, be it a federal high court or a state high court or the high court of the Federal Capital Territory. So these are things that will be considered in going to a court. Contract can actually also be enforced before a magistrate court or a district court, as the case may be. So the subject matter, the parties, and are the major consideration to determine the particular court that will have jurisdiction to entertain the suits.
Okay, thank you. And you have said that any of the two parties can approach the court in terms of a contract.
Yes.
Okay, and that the court can actually enforce the contract if it is violated.
Yes.
Okay, so are there situations whereby somebody who violates the court can be jailed?
Well, issue of jail has to do with criminal culpability, assuming that there is a criminal element in part of that contract. It can actually be taken separately. And for such a thing to happen, somebody has to commence the process by reporting or by petitioning to the appropriate law enforcement agent or agency that is responsible to investigate such a crime. It is after proper and doing this investigation that the agency can now make a decision whether to prosecute the person, in any court of competent jurisdiction or not. And if they decide to prosecute and they were able to prove their case, the person can go to jail, just like a criminal breach of trust. Most of the times, contracts are entered in trust, especially oral contract. And oral contract is what we do every day. There is hardly any day in our life that we don't, involve ourselves in one form of contract or the other. So it is something that you involve in without even knowing that you are even entering into a contract. But actually, when you look at the ingredients of your activities, you'll be able to know that there was a contract. So when you look at the aspect of complaint, the aspect of complaint will now determine whether there is a criminal element, and on proper petitioning on such criminal elements, it can be investigated and prosecuted. And if proven, the person can go to jail or pay fine, depending on what the court decides.
Okay, thank you. Let's quickly jump into another topic. You did mention trespass. So, and also you did mention, I heard of one word, tort. So let's go to that topic right now. What is actually a trespass, or what constitutes a trespass? And you can also, after that, you can also go into any other form of tort. My understanding is that tort is a branch of law or whatever. So correct me if I'm wrong.
Okay, actually, tort is a civil wrong. It's a civil wrong that, you know, we encounter every day of our lives, and is a branch of law, is a wide area of law. In tort, that's where you have the trespass you have mentioned, you have the defamation, you know, that can come in a form of slander or libel, you know, trespass to persons, and so many. And for trespass is an unlawful act of entering into another person's territory, or, you know, without permission or consent. That is what trespass is all about. So trespass is whenever you violate the right, the possessory right of another. The possessory right of another. It must not necessarily be land. Somebody can actually trespass into a car or any other item that you should have an exclusive possession. So that is trespass.
So let me give this simple example. If, for example, you have a cell phone, because this thing happens all the time, and somebody grabs your cell phone and start looking at things in the cell phone, is that considered a trespass?
Well, it's actually a trespass, because you, as the owner of that cell phone, has an exclusive possession of that cell phone, and you have the right to use it, you know, in exclusion of every other person. For one to go into your cell phone and start, you know, looking into what you have in that your cell phone is actually a trespass.
Okay, so how about a situation?
And that was why I mentioned that it must not necessarily be land, because our general concept about trespass is land. So it must not necessarily be land.
Okay, so how about a situation whereby somebody, I would say, a suspected criminal is just, after committing a crime, goes back to their residence and stays. So does the government have the right to just go into that person's proper residence or house or room, wherever that person is staying? So how does that work?
Okay, good. Now, issue of such an issue is what, you know, the police, or what we can see whenever the police is about to effect arrest. Once somebody commits a crime, it behoves on those persons that witnessed him, or the law enforcement agent that saw him committing that crime, to arrest him. So they can arrest him even if he runs into a premises. So they have right of ingress and egress. What that means that any law enforcement agent that is pursuing a criminal can actually break into a premises and pick up that criminal and come out of that premises. That person will not be liable for trespass. But that does not mean that when you see or somebody is being investigated for a crime, it's not as if you just witnessed that crime and you want to effect arrest immediately. It's a crime that you've been investigating over a period of time, and maybe after such an investigation, you have concluded your investigation. The last thing to do was just to pick up the suspect. Such a situation, you need arrest warrant. And that arrest warrant gives you the right to break into any premises that suspect is staying. If the suspect refuses to give up or give himself into custody, so it gives anybody that is armed with such an warrant to break into the premises and pick up the accused.
Okay, thank you. Now, you mentioned about defamation. So what is the defamation? Who should know about it?
Well, defamation is actually an act of, harming some other person's reputation and character by either what you say, by word of mouth, or what you have written against that person. If it is by word of mouth, it is what we call slander, and if it is written, it is what we call libel. So, issue of defamation affects the person, affects the reputation of the person that is being defamed. It harms the reputation and brings that person to, to low repute among those who may have heard what was said or who may have read what was written. So it brings the person in low esteem. When you write something that will make people to start looking at the person in another way, is actually defamatory.
Okay, so now if somebody is...
And that whatever you have written or said must not be the truth. It must not be the truth. But if whatever thing that you have written or said, if they are the truth, there is no defamation.
So if
it is only not the truth.
Okay, so if you say the truth exactly and you state the facts, so there is no defamation whatsoever, right?
There is no defamation.
It is only when somebody says something that is a lie,
yes.
That is when defamation can happen.
Yes.
All right, thank you. So now, if somebody feels that he or she is defamed, so what shall the person do?
The person can actually approach any a high court or any other court of his choice. When I mean any other court, he can approach even a magistrate court or a district court or a high court. These are courts that you can actually bring suits against defamation of character. So you can go to High Court of a state, but unless you go to High Court of a state or the High Court of the Federal Capital Territory, to apply for damages. You can actually apply for apology. Maybe some will say, let the apology be in 2 national dailies or in a national daily, a retraction of what was written, or something like that. Whatever thing that will satisfy you, that will make you feel okay, at least I've been compensated. And if the court sees reasons with you, the court will grant it. It can be by way of damages.
All right. Do you have to warn that person before you go to court, or can you go to court without warning?
You can go to court without warning. You don't need to warn the person.
Okay.
In fact, when you warn that person, actually, and the person ceases from doing that, you can no longer go to court, because you have gotten your remedy. You warn the person, either maybe he apologized to you and you're okay by it. You can no longer go to begin to complain, since whatever thing that you have requested and the person has complied with. Though it depends on the nature of warning that you gave to the person. Maybe you can actually, some will say, the warning can be in a form of that I'm requesting for an apology, retracting whatever statement that was made. If once the person complies, that ends it. It is now when the person fails to comply that you can now, approach the court.
Okay, thank you. So now let's go into another topic. If there is a case involving either 2 parties, maybe civil case or a criminal case, so and the judgment has been made, and someone is probably convicted, or somebody gets a judgment and the other person is not happy about it. So what are the processes of filing an appeal?
Okay. Now, appeal is more of a review of a judgment or decision of a court. So filing an appeal depends on the particular court that gave that judgment. Like a judgment of a magistrate court, the appeal lies on a high court. And a judgment of a high court, the appeal lies to the federal, to Court of Appeal. And a judgment of a Court of Appeal, the appeal lies to the Supreme Court. And that is the apex court. So because we operate different laws for our magistrate courts, different conditions apply for appealing a magistrate court decision to a high court. But because we have a uniform procedure in appeal from a high court to a court of appeal, I would like to restrict myself to just an appeal of a high court to a court of appeal. And appeal of a high court to a court of appeal means a review of a judgment of a high court. And that judgment of a high court can be a final judgment or an interlocutory decision, which might be in the form of ruling over a particular issue. So if it is an interlocutory decision, the person appealing, described as an appellant, has 14 days within which to appeal. And if it is a final judgment, the person appealing has 90 days within which to appeal. So, and for you to commence an appeal process, you commence it by way of filing notice of appeal. It is in that notice of appeal that you'll be able to describe the particular judgment you are appealing against, from which court to another court, and the name of the judge that delivered the judgment or the magistrate that delivered the judgment. In that your notice, you'll be able to also distill or show your grounds of appeal. That your grounds of appeal can be, either grounds of law or grounds of fact or grounds of mixed law and fact. And also, there are some appeals that are of right, while there are some that you require leave of court. The ones that are of right are like final judgments and appeals on grounds of law alone. But the one that you require leave, maybe appeal against a consent judgment or appeal against cost. Appeal against cost. So you require leave of court to appeal in such situation. Maybe when it comes to interlocutory appeals also, you require leave when it is on issue of facts.
So what does leave of court?
You file your hello?
Yeah, what does
you file your notice of?
Sorry, what does leave of court mean? Leave of court. You have said it a couple of times.
Okay, leave of court means permission of court.
Okay.
What that means is that for you to, have that permission, you need to, inform the court that I'm appealing against this decision of yours, and look at my reasons for appealing. The court will look at your reasons for appealing and your proposed notice of appeal and decide whether to give you that permission to go ahead and appeal or not. So if a trial court refuses you leave or that permission, you can go to the Court of Appeal to ask for that leave. And it is only when that leave is obtained that you can validly file an appeal. An appeal that requires leave, and you did not obtain that leave before filing the notice of appeal, it voids such an appeal.
Okay, now I have heard of this word, a tribunal. What level of court is that? Especially when there is an election and then they say they have taken the matter to a tribunal. So what level of court is that?
The tribunals, especially election tribunals, is presumed or is at the level of a high court. Tribunals is at the level of a high court because most times the panel, the justice that constitute the panel are justices of the high court. So even if there is a magistrate that is in the tribunal or in the panel, it must be presided over by a high court judge. So the appeal from such a tribunal will go to Court of Appeal. So it is at the level of a high court.
So which means any decision made at the tribunal, the appeal has to be appealed at the Court of Appeal, right?
Yes, it goes straight to the Court of Appeal.
Okay, so can any of the parties seek that what you mentioned, you call the leave of court, do you seek it at the tribunal or where? Or is there any such thing?
Well, you can seek it at that tribunal. You can
how about if the tribunal is dismissed? Because I'm made to understand that tribunals are ad hoc.
Yes, because of the nature of special election tribunals, the issues are taken together. Before now, election tribunals does not have a time frame within which to conclude their hearing, but with our present electoral laws, there is a time frame, and all interlocutory applications and appeals therein are taken together. So if you have any objection, it will be addressed while giving the final judgment. So issue of seeking for leave will no longer arise, because while appealing against the judgment of the tribunal, you will also be appealing against those interlocutory decisions that you have made in the course of delivering the judgment.
Okay. Let's go to another topic. A lot of Nigerians or people in the world generally, they like to do business. They try to call themselves businessmen or women. And there are businesses every single day, every single minute that is happening in this world. So if somebody in Nigeria wants to do business, does the person have to register the business?
Okay. Well, if somebody in Nigeria wants to do business, he can do his business as an individual without registering it. But it also depends on the nature and the volume of business the person wants to do. If it is just beyond buying and selling, maybe the type you see in the open market, where you see just the pepper seller, the crayfish seller, the fish seller, they might not require any form of formal registration for them to do that. But there are some specific businesses that for you to engage in it, you must have a formal registration. A lot of businesses that for you to engage in it, you must have a formal registration.
Can you give us some examples?
Just like if you want to do banking, for you to operate a bank, you must be fully registered and you obtain all the licenses for you to operate a bank. The same thing, the oil and gas business. For you to do such a business, you must be also fully registered for you to operate such businesses. And the list is unending. The list is unending. And any business you require license. And it is not just a license that is given to an individual to do. You have to register for them to now give that business the license to operate.
Okay, thank you. So now what's the process of registering a business in Nigeria?
Okay, well, there are two types of business registration in Nigeria. We have what we call limited liability companies, and we have business name. In that limited liability company, we have public limited liability company and private limited liability company. So it all depends on what you want to do. And for the business name is just more like a trade name. The business remains you, and the owner is also solely responsible. But that of a limited liability company, it must involve more than one person. The minimum you can do is 2. And once you register such a business, the business will now be separate from the individuals or the promoters of that business. So in Nigeria, we have the laws that govern business registration is Companies and Allied Matters Act of 1990. And in that Companies and Allied Matters Act provides for company registration in Part A. For you to register a company, it then means the promoters have to come together to provide a proposed name of that company. And if that name passes through availability check, where there is no other name or similar name, it can be approved. And in registering it, you need at least 2 persons. You need to have a share capital, and you need to specify your objects. It is that object that allows you to operate. That object is the notice to general world that this is the things that you can do, that these are the things that you want to be doing. So it is in the object that you describe everything that you want to do or that you are doing, and go ahead to carry on that business or after due registration. And your level of liability depends on your share capital. In fact, most people, tends to recognize registered companies. And for you to do, businesses in large volumes and at international stage, you need to be a registered company. And for you to even do government contracts, you need to be a registered company. A lot of things, that registered companies can do that individuals cannot do. So a lot of our people just carry on their businesses without thinking of that registration. And it is a limiting factor without them knowing it. Because once you register the business, it opens you up to a lot of possibilities that you can do or you can take advantage of outside from just buying and selling.
Okay, so how about non-profit businesses or organizations? So does it take the same approach?
Non-profit organizations, is provided under the passé of the Companies and Allied Matters Act. And such organization can as well, it can only be formed with at least 2 persons. The only thing is that they don't make profit, or they don't share profit. In the course of doing whatever object, aims and objectives that they've registered for, they can make money out of it. But the trustees or the owners of the non-profit organization cannot share whatever profit they have made. Whatever profit they've made, it must be plugged back into promoting the objects of the organization. And at the point of, even at the point of winding up, rather than share profit, they will move whatever remains or money they have made or property they have owned to another organization with similar aims and objectives that is still running. But the owners of a foundation, the owners of an organization, non-profit organization, can only, remunerate themselves for work done to the organization. The owners can actually serve in some cases as consultants or in any other way. They can actually remunerate themselves based on that, and they can actually refund their out-of-pocket expenses. But anything short of that, they cannot share profit, whatever money they have made from the organization.
Okay, thank you. We have one question from one of the Facebook contributors. It is not about business, but let me read the question. It's about trespass before we go into another topic. So the question, I'm reading the question exactly how the person wrote it. It says, how does lawyers or the court see situations which happen every day in the cities of Nigeria, where the police or other agents without warrant force phones or any other PDA from citizens who they say are fraudsters and search same by purporting them to unlock? I just read exactly what the person wrote. Yes.
Yes, actually, it is a sad situation in Nigeria. Very sad indeed. You see, most times, you see our security agents climbing into our privacy in the name of investigation. And like the example that was given in that question, they will collect phones, force the owner to open it, and they prime into the phone in the name of that they're looking for evidence. Actually, it is completely wrong and very, very condemnable.
So is it illegal?
The unfortunate thing is that most of those that their right has been violated will not take it up. So our courts cannot go out looking for cases like that. Somebody needs to bring such an issue before the court. That is the only time the court can actually look at it and now make the necessary pronouncement, if possible, award damages and possibly reprimand whoever that has done that. So the court is not a busybody. Somebody needs to bring such a situation, a case before the court. So if you are a victim of such a thing, the right thing to do is to consult your lawyer. The lawyer can take it up from there. He knows what to do, and you get, adequately compensated for such a trespass.
Okay, thank you. Now, let's go into another topic. You introduced yourself as hailing from Igbere. So let's talk about Igbere lawyers and possibly courts in Igbere. So, can you give me give us an estimated number of lawyers of Igbere extraction, especially practicing in Nigeria?
Well, actually, to give you a particular number will be very difficult, but I am pretty sure that we have over 100 persons, qualified legal practitioners from Igbere. Both over 100, over maybe 120 or so, we have from Igbere, because Igbere, have had a long history of legal practitioners. And our lawyers are everywhere in Nigeria practicing, and even outside the shores of this nation. So we have very senior lawyers practicing, doing their private practice. We have those that are practicing with the government as a civil servant, maybe in the Ministry of Justice or other government agency and parastatals. And we have those that are in the bench, judges, magistrates. So there is no aspect of the legal profession that is not duly and adequately represented from by the indigenous of Igbere lawyers.
Okay, so now you just mentioned judges and magistrates or something like that. So can you give us probably an estimated number of judges or magistrates who are of Igbere origin?
Well, I know that we have retired Justice Ikweche. He retired as a Court of Appeal Justice. And we have the present CJ of Abia State, Justice Ogwe, my Lord, Honorable Justice Ogwe, is also from Igbere. We have Justice Udogo, Chinyere Udogo, she's from Igbere. And we have Magistrate Ogoro E. Ogoro. And so many, I think these are the people that I can actually remember at the moment.
So how about Justice Benson Anya, am I correct?
Oh!
So we are listening.
We have Justice Benson Anya. So and he is our latest in the High Court bench.
Okay.
And we are so proud of him.
Okay, thank you. So now, does Igbere lawyers have any organization, a formal organization?
Well, we don't have any formal organization, but we have always identified among ourselves. We have a forum that has been in place, even before, even that's been in place as early as say 2000, 2002. That forum has been there. It's a Igbere Lawyers Forum, and because of the members are in different parts of the country, we always meet, interact, on yearly basis in Igbere whenever, we come back home for Christmas holidays. And with the advent of all these social media, we now have a WhatsApp group where we discuss issues relating to Igbere lawyers. And we have always, in as much as there is no any form of registration, but Igbere lawyers has always worked together as if it is a formal organization. Because we've had occasions whereby, the group would take up either a project or to take up a courtesy visit or whatever that any formal group can actually do. We have always done.
Okay. Before we go further into activities involving Igbere lawyers, you mentioned senior lawyers. So who are these senior lawyers, and how do you classify a senior lawyer?
Well, in the legal profession, we classify senior lawyers based on the post-core year. Your year of core determines your seniority. That is core earlier than the another is the senior. So, and when it comes to that seniority also, in the legal profession, once you attain the rank of SAN, if
what is that SAN?
you know, you now become a senior advocate of Nigeria. You'll be presumed to be the senior of any other person that is not a senior advocate of Nigeria. And in the Igbere, we have also had a good share of the agents. We have Chief Chris Uche, we have Chief Solomon Akoma, and we have Chief God Uche. These are our SANs that came from Igbere, and they are making waves when it comes to this profession, both in Nigeria as a whole.
So, and then, are there more lawyers who are qualified to be this SAM from Igbere who probably are not yet? In your own opinion?
In my own opinion, there are so many that are qualified, you know, to be given awarded the rank of SAM. And you know, the procedure is tedious, and it's more of, they use more of an eliminating method, because a lot of people are qualified on the face of it, but they cannot give it to all that have applied or that are qualified. They always devise a means to eliminate and reduce the number of persons that will be given the rank in any particular year.
Okay, now going back to Igbere lawyers, you say you have a group. Can the group of Igbere lawyers that are scattered across Nigeria or even outside Nigeria, can they be a branch of Nigeria Bar Association?
Well, they cannot be a branch of the Nigerian Bar Association, in the sense that such a branch can only be given to people practicing in a particular area. It doesn't matter where you come from. Just like for those of us that are practicing in Abuja, it comprises people from all over Nigeria. You know, you have people from all the 36 states of the Federation that made up the Abuja branch. So what determines any particular area being given a branch is the number of lawyers that are practicing in that area, not the indigenous lawyers of that area.
Okay, so now, are there courts in Igbere?
Yes, we have courts in Igbere. I know there is a high court in Igbere, and there is also a customary court in Igbere.
Is there any magistrate courts at Igbere?
No,
you know.
I can't remember of any.
Okay, now, are there lawyers that are practicing in Igbere or have a chamber at Igbere?
Well, I know most of our lawyers that take up briefs, you know, from Igbere are not really residing in Igbere. But I have seen one chamber, you know, in Igbere, one chamber in Igbere. So I know the lawyer, you know, that owns that chamber resides in Umuahia, but comes in once in a while to attend to clients and take instructions.
So what's the name of the chamber? What's the name of the chamber that is at Igbere, so that Igbere people will have the opportunity to, if they cannot go to Umuahia, they can go to that place?
Well, you see, we have to be careful, because why I say that we need to be careful in the sense that in our profession, we are not allowed to do advertisements.
Okay.
Or publicity.
Okay.
So it will not be proper to begin to mention any law firm on air since we are on live broadcast.
Okay.
But whoever that is in Igbere and goes around Igbere will always see, because I know that chamber has a signboard.
Okay, thank you. Now, because we are talking about Igbere matter, and some people have said, have argued, and they have a lot of comments or opinions, and they are not sure if Igbere Welfare Union is legally registered or not. I've heard of this debate. So tell us, is Igbere Welfare Union duly registered as a non-profit organization?
Yes, Igbere Welfare Union is duly registered as a non-profit organization. The registration took place when Professor Ijoma was the either interim chairman or ad hoc chairman of the union. So it was duly registered.
Okay. So now, final question. If something happens, for example, at Aba in Abia State, can somebody go to Abuja to file a lawsuit of something that happened to? That's the last question.
Well, it depends. It depends on what happened in Aba. Just like I have said in my statement, like on issues of fundamental rights, whereby you can go to any court of your choice, any high court, be it the high court of a state, be it the high court of the Federal Capital Territory, be it Federal High Court. You can go to any high court to seek for an enforcement of your fundamental right. So, assuming it is an issue of fundamental right, you can go to any high court. But assuming it is issue of land, you can only go to high court in Aba and no other. So it is not like a blanket thing whereby you can choose where to go. The law does not allow that. But the law has also made it very clear on where to go to, seek for legal redress. Now that you have mentioned this, just like on matrimonial causes issues, what I mean by matrimonial causes issue, husband and wife quarrel and all that, issue of divorce, you can go to any high court in Nigeria, even if the couple is living in Aba and all their quarrels took place in Aba, they can come to Abuja or even go as far as Maiduguri or Sokoto or Port Harcourt. As long as it is a high court in Nigeria, they can go to any high court in Nigeria to address their issue. And the reason behind that, because the law is such that everything that is being done, there is a reason behind it. The reason behind that of the matrimonial causes is just to give the parties an opportunity to express themselves the way they want it. If, assuming couples are living in Aba, they may have, like our Igbere situation, a lot of us are living in Aba. So it is difficult for you to see any person that doesn't have a relation, any person from Igbere that does not have a relation in Aba. It is almost practically impossible, But such persons can decide to go to anywhere outside from Aba, where it will just be only him and the wife. They can go there and resolve their matrimonial issues, just to enable them express themselves the way they want it, because it is it's an issue of emotions, and most times the parties will fight dirty. So that's just the reason why they can go to any of their choice.
Okay, thank you. We have just about 1-2 minutes. Is there any general advice you can give to our listeners?
Well, the general advice I can give to our listeners is that there is this saying, penny wise, pound foolish. Most of the times, we have things that we would have done rightly, but because you don't want to involve a lawyer and pay fees, you do it on your own, and you end up making big mistakes that will cost you more. I will advise our people to learn to consult lawyers. They can consult their lawyers in almost every aspect of their life. This profession is such that opens the mind of the lawyers to a lot of things, to be able to give them advice on issues that will help them. So it is good for you to consult a lawyer. Don't take it for granted. Don't take it for granted. Consult a lawyer for your businesses, consult a lawyer for your relationship, for your contracts, and everything, even in a lot of things. Just consult your lawyers.
Okay, thank you. Now, some of our viewers may have further questions. Obviously, I'm not a lawyer, so if they want to call to ask specific question on what we have said here, so which number can they reach? Okay,
if they want to call, they can reach me on 080 37 51 6640. 080 37 51 6640.
Thank you.
That's my private phone number. But another thing, I will also advise them to drop their messages in the forum page. I will be there to respond to it. And we still have other lawyers that are in that forum that can actually respond to those messages. So it must not necessarily be me, but once you drop legal issue in that forum, any of the Igbere lawyers that is in that forum will respond to it. Maybe that will be part of our pro bono and free services that Igbere lawyers are giving.
Okay, thank you so much for joining us in today's live broadcast. And then we will ask you to come back next time. We will let you know because there are so many things you have said which probably requires more explanation, and there are also some aspects of law which we may not have talked about today. So at a later date, we would like you to come back to this program. Now to our listeners, we thank you for being here with us today. We will announce next Saturday there's going to be another guest dealing with a different subject or even similar subject that we just talked about. Thank you for joining us. Thank you.
Thank you.
Bye.
Bye-bye.